This time in Georgia. So the Georgia Court of Appeals has agreed to review Judge McAfee's ruling that Fani Willis should not be disqualified from the case. So now they're reviewing that. Does this mean that the Georgia trial is off the table before the November election happens?
It doesn't mean it's off the table, but I think the prospects of getting this one tried before the November election are growing a little bit dimmer. So this is a really unusual procedural posture because we all saw that evidentiary hearing play out. It was something of a circus where Donald Trump and company were attacking the prosecutor, District Attorney Fani Willis, for having a relationship with one of her teammates. It was litigated in the full light of day, and Judge McAfee denied Donald Trump and his co-conspirators' attempts to have her kicked off the RICO prosecution that she, D.A. Willis, brought against Trump and company. So then there was no right to appeal that decision. However, there was an opportunity for what we call a discretionary appeal. Judge McAfee had to decide whether to grant Trump's motion to appeal the case up to the Georgia Court of Appeals. And Judge McAfee, I'm sure being confident in his ruling, granted Trump's motion. He filed the motion, and just now the Georgia Court of Appeals granted the motion. They're accepting the case for review. So they will be hearing this issue on appeal, whether Judge McAfee got it right or not. I believe he did. Here is the thing on the timing front. When Judge McAfee granted Donald Trump's motion to even file this appeal in the first instance, he said point blank, I will not stop. I will not stay. I will not pause my trial. We are going to continue to plow forward. We're going to litigate motions. We're going to do everything we need to do in the run-up to a trial date to make sure we are still on the trial track, moving in the direction of a trial. Judge McAfee, in his order, went so far as to say, even if the Court of Appeals grants review of this case, we ain't stopping. That was important. And now that the Court of Appeals has issued its order granting review, the first thing I wanted to do was look at it to see if they said anything about the stay. It's about a sentence or two. Let me read it. They say, upon consideration of the application by Donald Trump for interlocutory appeal, let me just stop there because we hear that word interlocutory all the time. It's not a word that we often use in our everyday conversations. An interlocutory appeal is an appeal that's taken while the trial is ongoing, before the trial is complete. That's all an interlocutory appeal is. Usually, you can only file an appeal after the entire case is over. There's been a conviction, the defendant has been sentenced. That's when you get to begin appealing things. This is a kind of a midstream appeal, an interlocutory appeal. Upon consideration of the application for interlocutory appeal, it is ordered that it be hereby granted, meaning they're going to accept the case for review. The appellant, Donald Trump, may file a notice of appeal within 10 days of the date of this order, and the clerk of the Superior Court is directed to include a copy of this order in the record transmitted to the Court of Appeals, period. What that means, Brian, is thus far, the appeals court has not sort of overruled Judge McAfee's decision that the trial case will continue. They will keep litigating motions. They will keep heading in the direction of a trial date that thus far has not been set.
And they were able to do that, just as a quick sidebar, because this wasn't a case dispositive issue as opposed to the Supreme Court, where the D.C. trial had to stop because if the Supreme Court ruled that Trump had presidential immunity, it was case dispositive and the whole thing would have stopped anyway. Is that right?
Grasshopper, you have learned the law well. I don't think I need to add to that. That was perfectly put. It's a really unusual case because they're trying to kick the district attorney off. But as you say, it's not case dispositive. Why? Because another lead prosecutor would be appointed and presumably would pick up exactly where Fani Willis left off. So no, it's not a case-ending issue.
Now, Judge McAfee will keep moving with these pretrial motions, but do you think he'll get to a place where he runs out of pretrial motions and where the appeal, the delay, actually does stop what could be the start of this trial?
Great question. I think the answer is probably no, because we still have 15 RICO defendants pending trial. So the prospect of running out of pretrial issues and motions, unlikely, because these folks will be filing motion after motion after motion, even if they're not meritorious motions, perhaps only to delay matters, right? And as of right now, as I mentioned, we don't have a trial date. The last thing we heard about a trial date was months ago when District Attorney Willis offered to Judge McAfee, I believe August 2nd, urging him to set at least the first trial date for some as of yet undefined batch of defendants, whether it's 2, 3, 4, 6, unlikely to be all 15. I mean, that is a big unwieldy trial. But it has been radio silence on when the first trial date will be set. And there is a chance that this issue that the appeals court has now accepted for review gets resolved in the next couple of months, and really any trial date that would have been set otherwise, let's say September, for example, might end up being completely unaffected, at least on the timing front.
But they can't set a trial date while this case is still being reviewed by the Court of Appeals. I mean, they can litigate these pretrial motions, but they can't actually set a trial date now until this issue is litigated, right?
You know, I'm not so sure. I actually think Judge McAfee could set a tentative trial date and say, listen, because it's not case dispositive, either District Attorney Willis will head up this prosecution or somebody else will be appointed to head up this prosecution. But Brian, the team, the prosecution team, the batch of prosecutors who have been working this case all along would probably remain intact anyway. So the judge could set what we often call a provisional trial date. So that means assuming all of the legal issues have been cleared up by the Court of Appeals, we can just go ahead and, convert that provisional trial date into a firm trial date.
And just a quick note for those watching right now, if you want to keep up with the coverage that Glenn and I are doing, not only of this trial, but the ongoing Manhattan trial, please make sure to subscribe to both of our channels. Glenn, this issue of Fani Willis having an affair was not only adjudicated, but Judge McAfee had even taken extra steps to ensure that it was airtight. Like Nathan Wade, who she had an affair with, is off the case. So why would the Georgia Court of Appeals actually agree to hear this?
The only reason I think they took it up on appeal is because even in isolation, setting aside the high-profile nature of the lead defendant, Donald Trump, and frankly, many of the other defendants like Rudy Giuliani, former chief of staff to the president Mark Meadows, corrupt high DOJ official Jeffrey Clark, and others, it's not surprising that the Court of Appeals would want to kind of put its stamp of approval or disapproval if they disagree with the way Judge McAfee resolved it, kind of put their stamp of approval on what is unusual litigation in the first instance, and then the remedy that Judge McAfee put in place, as you just noted, it was an either-or. Either D.A. Willis can remove herself from the case, she was one half of this ill-advised relationship, or Nathan Wade, the other half of the relationship, can remove himself from the case, and Nathan Wade, almost immediately after Judge McAfee handed down his ruling, he quit the team. He said, I'm out, I don't want to interfere. And the thing is, it's going to be really challenging for the Court of Appeals to go back now and potentially undo that if they think Judge McAfee's decision suffers from some, legal infirmity or deficiency. Really hard to kind of untie that knot. So I do think at the end of the day, the Georgia Court of Appeals was probably so interested in this issue, they wanted to take it up, even if they're not going to grant any relief to Donald Trump. But I think undoing Judge McAfee's ruling is unlikely to happen for both legal reasons and ultimately for practical reasons.
We haven't seen any movement in this trial, which you alluded to before. Why do you presume that is? Because in the other cases, they're at least trying to go to trial. I mean, Manhattan is on trial right now. D.C. is just waiting on the Supreme Court, who, is in the pocket of Donald Trump. Florida, it would go to trial, but is being purposefully caught and killed by Judge Cannon. So why isn't there any forward movement? Is it just by virtue of the sheer number of defendants in this case?
That would be my kind of informed speculation. It's such a big, unwieldy case. I've always kind of drawn the comparison and the contrast between what Jack Smith decided to do in D.C., indict only Donald Trump and leave everybody else as unindicted co-conspirators, undoubtedly to be indicted in the future. So that case was built for speed. Of course, the Supreme Court has, at least thus far, caught and killed that one, or at least put it on life support, and we're waiting for the Supreme Court to make its decision about whether a president is king and has absolute immunity against prosecution, make its decision, and hopefully return it to Judge Tanya Chutkan in D.C. so she can get that case to trial. But that case in D.C. was built for speed, even though it's bogged down at the moment. But the case in Georgia was built as a comprehensive vehicle to hold accountable all folks who committed crimes in violation of Georgia state law. And Fani Willis indicted 19 criminal associates, co-conspirators, co-defendants. So two very different approaches. They both, have reasons to recommend them. But I have to believe it's the sheer number, the sheer volume, including the number of motions that are still being litigated, that has bogged the case down in part and led Judge McAfee to thus far not even set a first trial date for perhaps a group of, 2, 3, 4, or 5 of the co-defendants. That I am surprised about. I think in the coming weeks, though, fingers crossed, we may be in a position to have at least one initial RICO trial date set down in Georgia.
Glenn, I'm gonna channel the frustration of some of our viewers here and ask, how do you retain trust in a system when day after day we are seeing how broken, how overtly partisan it is? Because there's really no reason for the Georgia Court of Appeals to take this issue up. I mean, it was adjudicated to within an inch of its life by Judge McAfee, just like there was really no reason for the Supreme Court to take up the issue of presidential immunity and whether or not Donald Trump is a king, and yet they both did. And I'm tired of the courts being treated as these righteous institutions that are above the fray of politics, when honestly so many of these judges are just Jim Jordans in robes.
It's hard to retain confidence in a system that I worked inside of for 3 decades. I try to look for the silver lining. I try to kind of pull back and take that 30,000-foot overview of what's going on. But I'm not going to lie, it is hard to continue to have trust and confidence in the legitimacy, if not of the system overall, of particular judges, because, like a Judge Cannon down in Florida really does seem determined to prevent what is an enormously consequential case from going to trial. A former president is charged with illegally hoarding classified documents, obstructing justice when the federal government sought the return of those documents, and violating our nation's espionage laws to the extreme national security risk of we the people and our country. And look at what Judge Cannon is doing with that case. It is hard to maintain trust and faith and confidence in the system. Here's what I'll say. One of my favorite sayings is Martin Luther King Jr.'s, "The arc of the moral universe is long, but it bends toward justice." And I believe that to my core. And I think when you pull back from the day-to-day frustration, you do see that arc of the moral universe bending toward justice. I feel the same way about the criminal justice system. The arc of the criminal justice system does bend toward fairness and the equal application of the laws to everyone. But right now there is a bit of a kink, a knot that has been tied in that arc by the Judge Cannons of the world and by the Justice Thomases and Alitos of the world. I think we have to work mightily to untie that knot, to unbend that kink. But I do believe that the arc of the criminal justice system will, in the long run, when you pull back, continue to bend toward fairness and equity and decency and the equal application of the laws. Even though, Brian, as you say, the day-to-day frustrations we experience sometimes suggest otherwise.
Yeah, and just building on that, I didn't ask that question so that people listening would say, like, you're right, I'm just going to throw my hands up in despair. This is all just, there's no resolution here on the horizon. The fix is in. It is to remind people that we can't rely on the courts to save us. And this is an issue that Glenn and I have spoken about, numerous times. But we know that there are issues with the courts. We know that there are issues with these judges, and there will be. And so once we become accustomed to that and we recognize that, then we can move past that and recognize that it's us who is going to save us. So that means it's us who has to turn out ourselves, our friends, our family, our circles of people to go and vote in November. We cannot we can't put all of our eggs in the basket that is these judges and these courts. So, I think that the important thing here is to recognize that, to kind of measure expectations moving forward and move forward with kind of a sense of what we need to do heading into November.
And here's what I would suggest, if this is helpful to some of our viewers who feel the same frustration we feel day to day, right? Try to take the frustration and convert it into energy and motivation and determination. Listen, my pop was a high school football coach, so, sports is in my blood, always has been, and I do sort of lapse into sports analogies, but when I was playing football, when I was wrestling, if we were down, if I was losing, I could get frustrated and just kind of lay down and let my opponent pin me, or let the other team run roughshod and score more touchdowns. Or I could turn it into motivation, turn the frustration, even the anger, into determination to fight even harder, work even more diligently. And you know, the one way that we can work, and we've talked about it before, is by not only getting ourselves to the polls, but get people registered. Help a friend get to the polls. I mean, there are lots of phone bank, door knock. There's so many things you can do. And even if you ordinarily wouldn't do it, take this frustration that we feel as a result of Trump and company trying to instill in us a sense of defeat and despair and despondency. Take it, let it energize and motivate you, and do things you might not otherwise do. Because at the end of the day, we're going to win this battle, even if it doesn't seem it when we're in the midst of our frustration and despair. We're going to win this battle, but the way we're going to do it is by voting in numbers too big to rig and too real to steal.